Thank you, Jaak. I think for us as attorneys, it is always a bit difficult to try and assimilate something like corporate governance into what the legal requirements are. We always tend to ask ourselves, well, how do you enforce this? What is the legal portion of this? Now, without going into exactly how this is enforced, I do think that one needs to understand, and specifically from a director's perspective, the duties that there would be on a director. And interestingly enough, if you start talking corporate governance, the Companies Act actually states in so many words that principles of corporate governance and the aspects that we are discussing here today are not limited to directors only, but it's also to people who act in a capacity that would expose them to some of the duties that will be normally associated with directors. So certainly in the company type of situation, it goes further than just directors. There could be other functionaries in the company that should also take cognizance of it. And also, as Ansi has already said, the intention of the codes at this stage is to take it wider than just application within a company. But if we just go back to normal common law principles, I think it's almost a basic principle that everyone understands, that a director's duty is always towards the company. There's a fiduciary duty that a director must at all times comply with. A director stands in a specific duty to the company, and the shareholders would stand outside of that duty and would obviously expect directors to report to them, but within the specific sphere of their duties from a fiduciary perspective. Now that's where corporate governance and a document like the King 4 report becomes extremely important, because it tries to explain to directors and other people in a similar situation what is expected of you in that circumstance and how to act. And therefore, it certainly does have legal relevance. And one cannot be ignorant and say that it doesn't apply to you. We'll probably get into some discussion specifically around the enforceability and legal aspects around that, where that will become a little bit clearer. But certainly there's a legal aspect to this which one can never ignore. Then the other interesting factor, and that comes from the way in which the new Companies Act is structured. I'm sure, as you know, we have a new Companies Act that came effective in 2011, and it in itself takes corporate governance requirements further than the 1973 Act did. So certainly that becomes more relevant to us as directors and functionaries who need to fulfill those roles. And what makes it difficult, and I think from that perspective, probably the authors of the code was in a very difficult position and must be commended on what they achieved, is that there's not a one-size-fits-all approach. Some of the tests are subjective. It depends on who the person is, to whom it is applicable, and therefore it becomes difficult to have a set of rules that you can follow a tick box approach with. And there needs to be flexibility. And that's exactly what the new draft of the code does. And certainly for every person who stands in a relationship to a company or another entity, it's very important to understand how that relationship works, what the tests are to determine, am I complying, or in fact, am I missing something here? And that's where the code tries to create that balance, and where an understanding of what is required from a company law perspective, if one looks specifically at companies, really becomes quite important for any director in that situation. But as I said, I think some of the items we'll deal with in a little bit more detail as we get to specifics. Ashley.